All right. This is the time set for a status in CV2021-005416, Greenfield Lakes versus John Zifcak et al. Appearances.
Good morning, Your Honor. This is Michael Hernicek. I represent the Zifcaks. Originally, the case was captioned with Greenfield Lakes being the plaintiff, so I was representing them as a counterclaimant, and I wanted to bring it to the court's attention that Paul Kular, who is representing the Zifcaks as defendants, is no longer involved in the case, and I believe the same is true of the Lewis Brisbois firm. So it's just Mr. Everett Schauser and myself.
All right.
Good morning, Your Honor. Jonathan Everett Schauser on behalf of Greenfield Lakes.
Okay. All right. It's Mr. How do you spell your last? Is it Hernicek? Is that right?
You got it, Your Honor.
Okay. Are you both okay if I file what I read that you both filed? I guess you emailed it to Judge Corey and he emailed it to me. Otherwise, there's nothing of record about what's going on here. I would just file your, I can tell you exactly what it would be. But that way there's a record.
Yes, that's fine with me, Your Honor. If it's the two documents you're referring to, sure.
Okay, the first one I'm going to print out is so there's there's Exhibit B, Exhibit C, Exhibit E, Zifcak breach of settlement agreement, Exhibit F, and Exhibit A. Those would all be printed out. I'm going to forward these to my assistant, and that's all by Mr. Hernicek by email to Judge Corey. Can't tell the date. Maybe June 14th? No. Oh, May 26th.
Yes.
All right, so we'll get all of that filed. I'm going to send that to my assistant to print out and file. And then what else do I have in here? I have and then there's response to settlement. There's a response by Brianna Roberts emailed it to Judge Corey. It's June 14th. So that response.
That's correct.
Okay, so I'll file those things. There's what?
It may be attached in the PDF, but there's one exhibit to that document as well.
Let's see here. Yeah, there's an exhibit. Looks like it's from Dustin Resch, Titan.
Perfect.
Exhibit 1. I don't know if I can get these photos. Then there's Exhibit D photos. I'll forward them. No, it takes me to an Adobe Acrobat Zifcak Exhibit D photos PDF. I'll send it to my assistant. I don't know if she'll be able to print those or not, but I'll send them to her.
If you need me to send the original JPEGs, I can do that, Your Honor.
Yeah, if you could send the JPEG. Do you want those filed?
That would be fine with us, Your Honor. I feel like we're in sort of this no man's land between official court proceedings and ADR, and Judge Corey generously volunteered to reinsert himself if there was some question as to the satisfaction of the party settlement agreement. So whatever you feel is best, Your Honor, I'm going to defer to your judgment. I
just think we need to have a record. Otherwise, you know, there's no idea of what you were asking the court to do, and then the court issues a decision, and then, you know, without what you filed and your positions, whatever I rule or decide would make no sense, and then there'd be no record of what you're asking for. You're both asking for a binding determination from this court, is that correct?
Yes, Your Honor.
Is that correct? And you're both asking for a binding determination that would be non-appealable, is that correct?
Yes, Your Honor.
You're muted, Mr. Everett Chelsea.
Sorry about that. Can you hear me now?
Yeah.
Yeah, that's correct.
All right. So I've reviewed all those documents we just talked about. I reviewed everything that I just sent to my assistant to be filed. The only thing I haven't looked at, there's some photos in some of those documents I referenced, but to the extent Exhibit D has additional photos, I've not seen those. So if you want me to see those, if you could forward those to my assistant, her email address. Do you need her email address? I can give it to you.
Is that Katrina? I just spoke with her earlier. I do have her email address.
You can send it to Katrina, yes.
Okay, I'll get those over today, Your Honor.
But otherwise, I've reviewed everything. So, I mean, I don't know how you guys want to go about this. If you want me to just decide based on the filings, if you want to be heard beyond that, or what?
Well, Your Honor, if I may, I think that there are a couple of ways forward, and I'm open to both of them. But one of them would be we would appreciate an opportunity to respond to Mr. Ebertshauser's response, whether you'd prefer that in brief or in a brief hearing. We're open to either or both if you feel like you would be assisted in either of those circumstances. But I think Mr. Ebertshauser brought up some points that we'd like an opportunity to be heard on. So I don't know that we need a 4-hour hearing, but I think maybe half an hour hearing might be appropriate. I think that if you'd prefer to just keep it to briefs, we can reduce our thoughts to writing and submit those separately.
What's your thought on that, Mr. Ebertshauser?
I don't disagree with Mr. Hrnacek. I think generally speaking, there are missing pieces in this conversation that need to be clarified. And I brought that up in the response. Essentially, we're talking about something that warrants evidentiary hearing, and I don't think it's in either of our parties' best interest to try to rack up fees and time and expenses in this process. But the reality is, it takes more than just say, hey, something caused damage to my wall. And so I think there is an element of this kind of back and forth conversation. I think we can do that in pleading, but I'm not sure I can tell you what procedurally that looks like. Because the information that Mr. Hrnacek is going to supply would warrant further response from my client as well. Essentially, all we've done is identified information that we don't have to evaluate this problem.
Well, I don't want to turn a mountain into
using this as a discovery process.
Well, I don't want to make a mountain out of a molehill. So, and I'm not suggesting it is a molehill. I don't know if it's a molehill or a mountain. I guess that's what's to be determined. But I guess the thought is, Mr. Hrnacek then files this response, and then you're like, well, now I need to respond to that because now I'm just getting this new information, and here we go again. And it's like, when do we say enough's enough? And the whole point of this was to get a quick, hopefully more inexpensive resolution to this. So I'm open to either. I just don't want to see this just turn into something it need not be. I mean, I can just tell you kind of my gut where I'm at right now, but in fairness to Mr. Hrnacek, I've not heard their position back on some of this stuff. But I could just tell you just kind of, if you want to know, just after I've read everything, kind of what my sense is of it. But if you don't want to know what my sense is, that's fair too. And it may not be fair to get it because I've only got the information that you guys have, which, in fairness to Mr. Hrnacek, there might be more to the story. I don't know.
Well, I can tell you from speaking to my clients without waiving attorney-client privilege that there is more to the story, and I think it would be helpful to direct our attention, both Mr. Ebertshauser's and mine, to address whatever gaps you perceive, and I think it would only help us and our clients to hear where your gut is leading you at this point.
Yeah, so on the first claim, I have the concerns that Mr. Ebertshauser raised. I mean, it's a little concerning that, there might have been some issues that pre-existed this wall being built. There's the issues with the waterfall being too close anyway and shouldn't be there to begin with, which raises an issue. Did the HOA approve the backyard design in the first place to allow the pool and the waterfall to be that close to the wall? I don't know the answer to that. I also don't know, it seems like factually they're denying that they did anything that when they built the wall that even came close to or near the fountain. So it just seems like not the strongest of claims right now. And And unless I had some more information to kind of explain some of that stuff away, like, hey, you know, they never complained about this being too close to the wall when they approved our backyard and our pool design, you know, that might be something that might help Mr. Hernachek's position. But just the idea of having some proof that they did something actually that affected or did something to that water feature, and what proof there is that they did, because right now they're denying that they did any work even around that water feature. So that in a nutshell is kind of my concern. And then the timing of the stuff. It looks like they got a quote before they even, was that date wrong on the quote? Because it
No,
looks
Your
like the
Honor.
timing was off. Like,
No, they had received verbal advice before they got the actual estimate, and the verbal advice was based on the inspection that preceded it, but they asked for something to be reduced to writing, and so I understand why the timing looks a little bit odd. As to your first point, I think Mr. Ebertshauser and I are going to probably agree that there is a difficult time in assessing what was there before, because the Zifcaks purchased the house with the pool and the water feature already in place, and I don't believe there's any record of the HOA approving or objecting to the water feature being that close, so that leaves us in a little bit of no man's land. However, our position is obviously going to be that if it was there, that it should be grandfathered in, and whatever reconstruction was to be done would need to take into account that water feature. And then we do have some photos, you'll see those today, where there was some cementing that took place between the new wall installation and the water feature. So anyway, I've got responses and I can address those, Your Honor, but again, I'm not sure how Mr. Ebertshauser feels, how you would like to proceed, but perhaps a brief hearing with the Zifcaks presenting their evidence, and with Titan Restoration and whoever else Mr. Ebertshauser would like to bring, might not help you make that decision a little bit with greater attention to detail, or with greater familiarity with the details, I should say.
right, but now we've got how many witnesses? We've got, you know, 2 pool experts, Titan expert, 2 plaintiffs. I mean, this is going to turn that it's a bench trial. So I guess if that's what you're asking for, you know, that's going to be expensive. And I'm going to be looking for some, okay, even if there's cement work, what's the proof that they did something that damaged that water feature? And I don't know, that means you got to hire an expert maybe to rebut their expert. And at what expense does this all get done? I don't know. I don't have the quote in front of me. I don't forget how much it is to fix that water feature. But at what point does it make sense here to pursue all that? You know, I understand you're going to be asking for attorney's fees and costs, but I understand the homeowners association will be as well, because on the next claim, even if you didn't prevail on that claim, Mr. Hornacek, I do think it makes some sense, good faith and fair dealing and reasonable expectations. I mean, if you're going to rebuild a wall, I wouldn't expect it to be rebuilt in a way that doesn't look the way that it was before, connecting to my neighbors, and I wouldn't expect to see gaps. I understand it might be to code, that it's built to code, but to put a wall up that doesn't look finished and has gaps between my wall and my neighbor and looks not good, I mean, that can't be in the homeowners association's best interest, or any of that's not going to help with values for homes in there. I mean, I don't see that. I don't see how they would do that unless structurally they couldn't, because maybe the neighbor's wall is crooked and that wall would have to come down to make it connected properly. But I don't know. I think if I was a homeowner, my expectation would be when you're going to rebuild the wall, I'm not going to have gaps and holes and things that aren't capped that look incomplete. But I would expect it to be rebuilt in a proper way that it was before. That just seems like common sense, but maybe I'm missing something. Maybe you would tell me, well, then you're going to have to tear down the walls of the neighbors and make those properly built so that they can all be connected straight. Well, maybe that should have been done to begin with. I don't know whose responsibility, the developer or the homeowners association, but I mean, I guess that's my gut on it. It's just that just doesn't make sense to me, just common sense. The other one's more of a real factual kind of expert issue, and you know, really I haven't studied the settlement agreement, but the first claim really seems like a new claim. It's just like you did some work and caused me damage. I don't know that it has really to do with it arises out of maybe building the wall, but the second issue really just seems like, was the wall built as contemplated by the settlement agreement? The other one seems possibly like a new claim, and maybe that's why it's more difficult to resolve. That's just my my gut. off the top of my head, response to reading all this stuff. I'm not sure that's helpful or not to you folks.
No, it's very helpful, Your Honor. I'm going to reach out to Mr. Everett Schauser today and see if he and I can't come to some sort of resolution just based on your preliminary remarks. But I nonetheless think I think you're right that if this was something that evolved into a bench trial, the tail is going to end up wagging the dog in terms of attorney's fees and expert costs. So my proposal would be, Your Honor, and I'm sorry for interrupting. I hope I wasn't.
No, you're fine. You're fine.
My proposal would be that you would assign us some sort of a briefing where I have an opportunity to submit a reply, and then Mr. Everett Schauser has an opportunity to submit a SIR reply if for some reason he and I are not able to come to some sort of amicable resolution before those briefing dates.
That sounds fair. So I'll give you dates, and then after you guys see everything, when you do your response or your reply, can you let me know if you want oral argument or an evidentiary hearing, or if you want me to decide it on the pleadings? Tell me your perspective after you do your respective responses and replies based on what you know at the time. And then after it's fully briefed, I don't know, I hate doing it. I don't like setting status conferences, and then they're not necessary. But I almost feel like after it's fully briefed, I wanted some way to check in before I spent the time ruling on it to know whether you guys even needed me to do that or needed anything else. Let's do this. The response by when? You give me a date, Mr. Hernachek, and I'll honor that date. You just tell me when you'd like to get your response by.
If we could do 30 days out, that would be great, Your Honor.
Okay, so look here. That would be August 12th. Is that good?
That's great, Your Honor.
All right, so the response by August 12th and the SIR reply?
Your Honor, just not knowing what we're looking at, I suppose a 30-day response would be appropriate as well.
All right, so September 12th.
I hate to kick it out that far. I'll certainly file it earlier if I can.
Okay. Then what I'll ask for is the following week, September 19th. On September 19th, please file a joint status report. That way I don't have to put something on the calendar, and I'll just get a joint status report from both of you saying, okay, Judge, you got the response and the reply. Here's where we're at. Now we've had time to digest. If you want more time than a week, tell me that and we'll give you more time. But then that's like, okay, we've digested everything. Here's where we're at. We either don't need your help anymore, we do need your help, and here's how we need it or would like it. You know, set a status, don't set a status, whatever. Oral argument, evidence hearing, whatever it is you're requesting. Even if you have differing views, you can each tell me in this joint status where you think this case should go and how. And if at any time it settles between now and September 19th or whatever date I set for that joint status, then I don't have to worry about it.
Perfect.
Very good.
So tell me, how much time do you think after you get the reply would make some sense? Maybe probably more than a week, huh?
Yeah, I mean, probably not more than 2 weeks. I think that we can be prepared in that period of time. I know the Zifcaks are eager to resolve this, and I believe the HOA is as well.
Okay. So I'll just set the response is due August 12th, the SIR reply September 12th, and the joint status report by September 26th. If you get it to me sooner, fine. If not, that'll be due by the 26th. And so by September 26th, I'll have an idea, if it's not resolved by then, where you guys are at and what you think needs to be done as next steps.
Very good.
So,
Thank you, Your Honor. I appreciate that.
and again, please understand, I'm not locked into those thoughts. That's just after reviewing what you guys told me. I mean, I just know what that says, and that's just my initial gut on it. So there could be more to the story. There could be more to the story, and I'm certainly willing to keep an open mind to learn more of those stories. So I get it.
Thank you, Your Honor.
Okay. Anything else from Mr. Hernachek?
Nothing, Your Honor. Thank you.
Mr. Evertschauser, anything else from you, sir?
No, Your Honor. Thank you for jumping into this. I think Mr. Hernachek and I both recognize that this is kind of a difficult thing, and appreciate your willingness to jump in where Judge Corey got away.
Yeah. Well, we can send it to him in family court. I'm sure he appreciates it.
Yeah, right.
Yeah.
That's his punishment. There you go.
Yeah, right. All right, guys. Have a good rest of your day. Stay well. We'll hear from you when we see you or hear from you next.
Thank you.
Thank
Thank
you.
you, Judge.
All right.